Good morning, everyone. We're going to go ahead and get started. This panel is called How Do We Get Our Money Back? Civil Forfeiture Remedies. And I'm Deborah Lopravat. I am a retired FBI agent who spent my time with the FBI on the International Corruption Unit, seizing the proceeds of foreign corruption. I was very fortunate to work with my former colleague Dan Clayman from DOJ. I was the investigator, he was the prosecutor, and I'm on the other side of the house, so I'm very happy to be with my colleague Catherine Mulhern from Restitution. So I've seen the options for recovering or civil litigation from both sides. When I, over the last 28 years of being an investigator, have gone from country to country to country, and countries have been looted of assets, or they have a multinational company that has paid bribes or skirted taxes or in other ways done damage to the country, every country that I've been in has the same challenges, and those challenges are: maybe we don't have the ability to trace the money once it leaves our borders, trace the money internationally. We don't have the funding for for the personnel in an anti-corruption commission, or not enough law enforcement specifically trained, or just the personnel needed to do these long, complex investigations. And then lastly, the expertise. So it's funding, personnel, and expertise. Those are the challenges that I found in almost every country. So in those situations, you might have to go outside of your borders to request additional assistance. And so our experts here today can discuss with you some of the options that you have, whether it's a civil forfeiture for asset recovery, civil litigation to go after a multinational corporation. I'm going to introduce my wonderful panelists today. To my right, I have Dan Clayman. Dan is the Principal Deputy Chief at the International Unit at MLARS, which is the Money Laundering Asset Recovery section of the U.S. Department of Justice. We have Fiona Fentress, who is a partner at Pallas Partners and does litigation. Catherine Mulhern is the CEO of Restitution. And then Jamie Smith, who is the Senior Policy Specialist at the Anti-Corruption at the Swedish International Development Corporation Agency, SIDA. So we're going to start today with Dan Clayman. And as I said, Dan and I were fortunate enough to work together for years. I will point out also Mary Butler, who is in our crowd. Mary is the chief at DOJ's Money Laundering Asset Recovery section. Very wonderful to have you here. Dan, I'm going to pass this off to you.
Well, thank you, and I appreciate everybody getting here at a crazy early hour to discuss what I think often is a rather technical area, and at the risk of it being further technical, I'm going to try and quickly go through some terminology. And I had originally thought maybe a little bit more of a dialogue at the beginning might be useful, but I think it's important for us to have a common set of terms, because I think we often misunderstand the different tools. And so at the risk of it being a little bit too lecture-y, especially for those who are practitioners, I am going to try and go through a little bit what the tools are that the government uses in asset recovery. I do like to start with thinking about what are we looking at, and what the types of issues we have that we're fighting in corruption cases. Here are some of the faces and some of the assets, especially down below here, some boats. I don't know if you can see them in the back, that we encounter in the grand corruption and kleptocracy space. And I like to put up some of the pictures of those whose assets we've been chasing, or, because it shows that there's assets sort of all around the world, and corruption isn't unique to any particular region or country of the world. I think since our work in the Kleptocracy Asset Recovery Initiative, it keeps advancing on me here, is focused on foreign corruption. There's we aren't including, I have included heads of from the United States where we do have our own challenges in corruption, where we continue to have to be vigilant ourselves. And I think also maybe in a future iteration, we should start also including some of the enablers who we prosecute and convict for these types of crimes. But corruption is everywhere, and money laundering is everywhere, and so their assets are everywhere too. This is an example from one of our early asset recoveries. It's from 2006, I think, 2004, when we repatriated about $20 million to the government of Peru related to Montesinos and Fujimori. It's an interesting case in that it was before we had sort of a dedicated unit, but it's part of our experience that led us to dedicate specific resources to foreign asset recovery cases. And once again, it's automatically advancing a little bit. And I think one of the other interesting things about this case is that while we repatriated $20 million from a non-conviction-based civil forfeiture case in the United States, that wasn't the full extent of our cooperation with our partners in Peru. We also worked with them to identify assets in the Caribbean that were under Venero's control, but were actually Montesinos' assets. And because of that, and once we extradited Mr. Venero back to Peru, he was under pressure to voluntarily repatriate some of those assets. So sometimes the confiscation proceeding itself isn't the only result that you can see from a law enforcement investigation. Around the same era, we also repatriated some funds to Nicaragua in another case. Happy to talk about that a little bit further. Here is a more recent example. In 2020, we repatriated $311 million to the government of Nigeria. And then in 2022, we sent another $20 million back. And we're working on further repatriations, all stemming from a multilateral effort and a good case of international cooperation between several different jurisdictions, including most notably in this picture, my boss, Kevin Driscoll, one of the Deputy Assistant Attorney Generals in the Criminal Division, the Attorney General of Jersey, Mark Temple, that some of you may have seen earlier this week, and the former Attorney General of Nigeria, Mr. Malami, who were celebrating the return of these $311 million. So this is another way that we're able to work together by taking an action in one country and enforcing a judgment in the other. So there were violations of U.S. law that we were able to advance in a civil forfeiture action, and then our colleagues in Jersey, in the UK, and now also France have enforced that judgment. So this is an ongoing case. We're hoping to see more repatriations soon in that case. And then finally, I just thought I'd throw up a little bit of an example from our 1MDB case, which is probably our biggest case of asset returns right now, where we've recovered or assisted in the recovery of about $1.4 billion to Malaysia out of that scheme, and that's through the confiscation process. There are other criminal penalties against the bank. Some of those also offset where there were criminal and other proceedings in other jurisdictions, including Malaysia. But in terms of the asset recovery piece of following the money out to the proceeds of what the criminal perpetrators obtained, this automatic advancing. And that it was around $1.4 billion that we've assisted in returning. So this is the somewhat technical part. I thought because of some of the discussions I've had over this week, I do think sometimes we talk about seizure and forfeiture and asset recovery in sort of a big sort of mix. And I think in terms of understanding how do we get our money back, it's important to know how those, how we can have a common discussion about what those terms are. And so, first of all, the primary government tool that we have is confiscation. We call it forfeiture in the U.S., but we're a little bit alone in that. So I'll try and stick to confiscation if I can. And the result of confiscation is that it extinguishes the prior ownership of the property because it's involved in crime or because it's part of a criminal penalty. And there's advantages to that because then the government owns the property after the confiscation, and anybody else who comes after has lesser title. And so it's a very effective way of clearing title to property when you're trying to recover it and get it back to the people harmed by the underlying corruption. It is a government authority. It's one that is, it's a police power, it's a law enforcement thing, so you're not going to be seeing that in civil society or civil lawsuits, which my colleagues are going to talk a little bit more about. And so it's not a private remedy. There are two basic sort of types of confiscation. There's criminal or conviction-based confiscation, and there's also and there's also non-conviction-based confiscation, which some people call civil forfeiture, like we do in the United States. And so the title of our talk today talk about civil forfeiture remedies, but civil forfeiture really is just the government's mechanism for confiscating property when it is attacking the title of the property itself without a criminal prosecution, or maybe ancillary to a criminal prosecution. And so it's not necessary for us to convict someone when we can prove that the property was involved in the crime. So unlike in a criminal or conviction-based system where we're proving criminal responsibility first by an individual or a company, in a non-conviction-based system or a civil forfeiture system, we are essentially prosecuting the property for its traceability to the crime. And then both of these systems have extensive procedures for protecting third-party rights and that sort of thing. Some of the things that civil forfeiture and criminal forfeiture are not is seizure. Very often, seizure and restraint gets conflated with confiscation, and it's really just a temporary measure to preserve assets during the course of the proceedings so that you can actually have something to forfeit at the end of the day. And it's also not a criminal restitution, which is payment the court orders a bad actor to pay some kind of compensation to someone harmed by the underlying conduct. And it's sorry about this here. I don't know why it automatically advances for me. It's also not a criminal fine. And the other place where I think we hear some overlap is with freezing in the context of sanctions. Sanctions are a very different animal. They're not an exercise of law enforcement power. They're an exercise of national security powers. It's like a mini declaration of a state of emergency with respect to something specific. And because of that, they basically just make it so you can't deal with assets. It doesn't recover the asset, but it does block them. It's a passive sort of type of block. The way there is some overlap is if someone violates the sanctions, then they're committing a crime, and that can itself give rise to forfeiture. And that's one of the things that we see in some of our klepto-capture cases involving Russian oligarchs who have been sanctioned under our national security powers. Private civil litigation also is not confiscation. It's not forfeiture. It may be civil, and there may be civil forfeiture, but they're somewhat different animals. And as I'm sure my colleagues here will discuss at more length, they're often based on a sort of a damages theory, or maybe there's a constructive trust, or there's different theories of why you can recover in civil litigation, but those are generally private remedies where a foreign government may be itself taking self-help measures to try and recover assets in connection with criminal activity. Oops. So a couple of the advantages of the confiscation mechanism is that it really, whoops, having real issues here. Is that you do have the criminal investigative powers through confiscation. Because it is a government law enforcement action, you can do all the things that you can in a criminal investigation. You can get search warrants. You can break bank secrecy with a subpoena, and those are really powerful tools that are, I think, harder to address in civil litigation, but that are sort of bread and butter for law enforcement. And importantly, I think mutual legal assistance is often misunderstood, but mutual legal assistance is the mechanism through which governments can exercise police powers in another country. So the United States law enforcement has no legal authority to act in Lithuania, and the Lithuanian law enforcement has no power to act in the United States. But if we want to break bank secrecy in Lithuania because we need bank records to prove our case, or if we need to conduct a search warrant or compel the testimony of a witness, we can make a mutual legal assistance request, and they can evaluate it, and if it meets their legal requirements, they can exercise the police powers on our behalf. And so while mutual legal assistance may sometimes be slow, and it is sometimes slow, there are often good reasons for that, because you have to make sure that you're exercising the police powers of your own state on behalf of another state with justification, just as you would in your domestic actions. A couple of the other couple other advantages of a confiscation approach is law enforcement has access to other types of information that you may not always have access to in a private litigation. Things like financial intelligence, when banks essentially report on their own clients when they're undergoing, they're taking suspicious actions with their funds, and or tax information, and so there's that type of information that is going to be much more protected. Beneficial ownership registries, I think we're seeing a backlash against the public beneficial ownership registries. So I know the one that's coming on in the United States is going to be really only accessible by the government. It's not going to be accessible sort of widely, and I think there's a robust debate about whether or not that's an appropriate model or not. But I think the reality is that in a lot of investigations, beneficial ownership information is going to be under some kind of lock and key, sort of the way suspicious activity reports are. Generally, I would say our investigations are less costly for a foreign government that's looking for assistance, because we're already invested in ensuring that crimes that occur in the United States or using the U.S. financial system are resourced and investigated, and we want to find the criminal actors who violate our laws through money laundering as well. And so I think while sometimes law enforcement in different countries will recover costs, I think generally speaking, in the case of grand corruption, where there's recognition that that there's damage caused to another state, those costs are generally limited, and so I think those can be much more minimal in an asset recovery case brought by the governments. And then I think there's also a way, by using confiscation, you also avoid some of the risks that are inherent in civil litigation, like open discovery and risk of counterclaims that may open a government to some degree of risk. But in confiscation, since it is a sort of a police power, that generally can be avoided. In repatriation and return, let's see, I don't know where this is. This is, I think I'm just going to try and wrap here. So repatriation and return, I think this is an area that I think could use more discussion. How do we do this better? I think when UNCAC came up, the Article 57 was a kind of an uncomfortable compromise. But there weren't that many practical cases of asset recovery where there were actually results. And that's why the international framework of UNCAC doesn't go into a whole lot of detail as to how to do the returns. But now that we're seeing more recoveries in more parts of the world, I think it's an opportunity for us to engage in how do we make sure that funds are not re-corrupted? How do we protect the sovereignty of nations in determining how to spend money on behalf of their own people, but at the same time ensure that civil society also has information and access to information about how funds are repatriated. And so I think that's an important sort of further topic. I would note that there are risks in corruption. Remember this picture that I showed at the beginning in 2004? Here we've got the two foreign ministers from the United States and Peru signing an agreement to repatriate the $20 million. There's my boss at the time, Mary Lee Warren, and standing next to her is President Toledo from Peru, who, as many of you will know, has now himself been embroiled in the Odebrecht scandal and is being prosecuted in Peru. We actually recovered funds related to Mr. Toledo and repatriated those to Peru fairly recently. So corruption isn't something that you turn off with a switch. It's something we have to be continually vigilant for, and I think that also goes in the context of the repatriations. Asset recovery is not a simple thing to do, even through confiscation, with all these powers that we have through law enforcement. We still have a number of difficulties, including the three that I've highlighted here, which is we always have to try and have difficulty proving the underlying crime. I think there are also very strong presumptions in favor of property rights. You would think that your liberty interest is higher than your property interest, but it's much easier to extradite a person than it is to extradite property. To extradite a person, all you need is probable cause and an extradition treaty. But when you are trying to repatriate assets, you need a final confiscation judgment, and it has to be enforced through sometimes laborious and repetitive procedures that don't always match up from country to country. And then, as I mentioned before, I think we still have challenges in the new frontier of how do we recover and repatriate the assets in a transparent and accountable way.
Dan, I have a question. For people who don't know, what gives the U.S. venue to help foreign partners?
Well, we need, most of our cases are territorial based. So if that means if there's some conduct that occurred in the United States, it doesn't always have to be a lot of conduct. It can be a financial transaction. That may be a sufficient basis for us to initiate a case. And so we have a number of cases where the underlying corruption occurred outside the United States, and the assets that we're trying to confiscate are also outside the United States. But because the person directed some of the conduct from the United States, or even transferred money through the United States, established shell companies in the United States, that may be sufficient to give us jurisdiction. It's not always that the use of a U.S. dollar is going to give the government in jurisdiction, but it's often the case that there's territorial conduct. And then there are some cases where we have an ability to go after U.S. nationals or conduct occurring abroad by U.S. nationals. But we do need some kind of nexus to the U.S.
Thank you. As Dan shared with you, so civil forfeiture to go after the proceeds of kleptocracy, to go after corrupt proceeds, is one of these civil remedies. I'm going to hand the mic off to Catherine, who is going to talk about what happens when it's not the proceeds of corruption, but a company has done other things, going after claims. And well, Catherine, you can say it better than I can. I'm going to hand it off to you.
Thank you. Thanks. So, Deborah, just in terms of timing, how much time do we have?
You have 15.
Okay,
20.
fine. Yeah, I'm a litigation funder, so it's interesting to speak about litigation funding for 15 minutes. I'll tell a couple of war stories, which may help pass the time. But so, Dan, I was actually on the opposite side of a couple of these. So my background is a lawyer. I'm not a litigator by background, so my focus is primarily on governance, and the work that I did both in private practice and as CEO of human rights litigation NGOs was working with governments, typically newly democratic, post-conflict governments. So I would sit with ministers of justice and presidents when they went into the office and figured out what it was that they had and what they were working with. And then we did send some MLARS to the U.S. and didn't get a response. So apologies, I'll re-forward them. But I think for us, in working with people who were very much, okay, we've just been elected, newly democratic governments, we have people who are counting on us. More often than not, what we would find is the Minister of Finance who would walk into and look at the Treasury. Often the Treasury was significantly lower than what they expected. So they had made promises to the people. And as a result, when they were looking at what they actually had, they often found that they didn't have what they thought they had. So the work that I did with ministries was, and I'm an investigator and governance person by background, I was often asked by ministries to go and have a look to see if we could find out what had happened to the money. So, and it was a very simple question that we were asked, a very complicated answer that we needed to give. So, and anyone who has investigations experience here will know in many ways an investigation is a lot like being in the dark with an elephant. So you feel one part of the elephant and you sort of recognize the trunk, you feel another part of the elephant, but it takes a while to figure out that the elephant is an elephant. And I was working with one country, the Gambia, was asked to work with them. I was the CEO of an organization called the Institute for Human Rights and Development in Africa. We got to know the opposition, which then became the government, and we were asked to go and sit with the president and the minister of finance and do exactly this, that the treasury was significantly lower than they expected. They knew the former dictator had taken significant amounts of money, but it wasn't clear how it was taken. So they knew it had happened, but they needed to start piecing together and then piecing together remedies that they could potentially use to get that money back. So we went and we hired a large investigations firm. The investigations firm started to do two things. It started to look for where the money potentially had gone. And in the context of this sort of transition from dictatorship to democracy, often the money is taken in ways that most people would find absolutely terrible. I mean, it was people going into banks and just taking money out and putting them into suitcases and going across the border. So it was not very sophisticated. But on the other hand, there was also tremendous sophistication to what we started to term the architecture of corruption. So I know the penny dropped for me. I was with the permanent secretary of the Ministry of Interior, and I walked into her office one morning, and she said, we had a break-in in the office. And I said, and it's one of those things when someone tells you that your heart sort of drops. And I said to her, what's been taken? And she said, we don't know. So she and I and a couple of other people from the ministry started going through her files to try to figure out what had been taken. And we found, and again, this is, in thinking about it, quite an eerie thing to have found, but somebody had taken a straight razor and had razored out documents from her files. And then, so with this particular government, they kept multiple files with multiple ministries. We called another ministry. The ministry had the same issue. But then we had the Ministry of Health, the permanent secretary, had been with the government a very long time. She had a bad feeling when the transition was happening, so she took a lot of documentation home. And she had what had been stolen. And what we found are about 10 contracts that had been razored out from these files. And we looked at the contracts, and the various permanent secretaries didn't recognize the contracts. They didn't recognize who had signed them. The contracts for services, very significant services, like, for example, telecommunication services. So the entire long-distance telecommunications of the Gambia were covered by a contract. Oil and gas, mining. And so we asked the investigator to go and look at who these counterparties were, because we didn't know who they were. And what came back from the investigator was there's now a pattern here where it's Swiss companies, often shell companies, that the directors are listed, but they're listed on several companies that have several different deals with the government, the former government. So it's mining, it's oil and gas, sand mining, telecommunications. We then looked for these people, and these people were effectively ghosts. So then the ministry started to speak to other ministries within West Africa and ask questions about these people. And it turns out that these people had turned up all over the region, doing exactly the same thing. So then we said, okay, we have a couple of things we need to do. First, we need to, so these contracts were still active. So in the telecommunications space, anyone who works in telco, it just sort of clicks over these telecommunications contracts. And a lot of the mining contracts, the oil and gas contracts, a lot of these licenses were still outstanding. So we looked at what remedies we had, and we said, okay, we think that this was the architecture for the extraction of money. And for this particular country and other countries that I've worked in and done similar work with, the money that was taken was significant. So we're talking about a very poor country in West Africa. We think about 2 billion was taken, so which is extraordinary. So we said, okay, how are we going to get this money back? So we sent out MLATs to various folks in various European jurisdictions. We did send in, and Dan, to you, all joking apart, the U.S. was responsive. So we did manage, or I say we, the Gambian government did manage to get some money back. So, but others were not as responsive as you. So I said to the government, we should sue these people, because this is fraud. They have contracts. These contracts are not providing anything. And they said to me, well, this costs a huge amount of money. A lot of these contracts are UK jurisdiction. We're worried we're going to get sued if we sue them. And so really, and in terms of that, then what we started to do was terminate the contracts. So we took legal advice in the UK, we took legal advice in the country. We started terminating these contracts. And I swear to God, we got so many strike suits and vexatious arbitrations from these people. I mean, there were, Swiss sham companies sending lawyers' letters to us saying, we're going to sue you. It's like, well, there's nobody here. Who are these people? But we did terminate. We terminated the contracts. But one of the things that the government said, and other governments who we've spoken to since have said, is we would like a remedy that is under our control where we can go after these people, right? They have stolen billions of dollars from us. We can terminate these contracts. We see the architecture, but how do we get our money back? And that's really where restitution started. So for me, I'm one of 7 founders who are human rights professionals, development professionals, lawyers, investigators. and others as well. We have mathematicians and investment bankers who look at these claims from a very quantitative perspective. And what Restitution does is we are one of a handful of impact litigation funders. And what we do is we work end-to-end with a certain type of government, typically transparency focused, so we do a lot of diligence on our partners. They have to be on the right side of sort of civil society folks. We spend a lot of time with civil society and country. They have to be on the right side of the Transparency International Index. But if they fall within certain parameters, what we do is we work with these governments end to end. So that means we go and we provide capacity building to ministries. We help them start thinking about these, converting these types of contracts or this type of fraud into a type of claim. And that claim could be, and that's the other thing that we thought about at the time, and I thought about at the time, is we've got to get these guys, and we've got to get them in the jurisdictions where it's going to hurt them the most, right? So it's in the UK, in the US. Where are they listed? Are they listed in Switzerland? Well, we need to be able to bring an action in Switzerland because that's going to embarrass the hell out of them. So all of those things sort of went into Restitution. So what we do is we develop the claim. The claims then become, in a sense, investable. So we have impact investors, and those of you who work in the impact space know that impact investors will invest in these types of claims and assets, but they have a double bottom line. So they're very focused on the output. So what happens to the money once they invest? So we have impact investors who invest in these claims to go after, say, a company like this company, not to be named, in the UK courts for unlawful means conspiracy, which is a tort, typically costs about 20 to 25 million. But what that gets you is the best lawyers, the best investigators, but it also gets you insurance. So you have after the event insurance and adverse cost insurance. So if they come after you, which eventually they will, you have those sorts of protections. And you also have money to say, we have deep pockets, we're going to wait you out, and we are going to get this money back. So, and then we work with the governments to say, once that money is returned, and it's, for us, we are not asset recovery people. So we go after judgments and awards, which means for us, we can look at, for example, lost profit. So say a company has extracted value from a country of $1 billion and then has invested that $1 billion to grow its business. Potentially, under equitable revenues, we can get that $1 billion plus, right? So it's not dollar for dollar asset recovery, it's judgments. And what we do is we go after these companies, we either settle or we go to judgment. We get the money, and then we work with the government to make sure that that money is used in line with their national priorities to essentially provide funding for the environment, for communities. They often have, green hydrogen for one of our clients is a very big focus. So those are the sorts of things and projects that we work with them to fund. So essentially we help ring fence that money with the agreement of the government so that it's used in a way that's protected from re-corruption. So, and what we're finding, we are one of a couple of impact litigation funders, but we're the only ones that work with governments. And this end-to-end approach is the approach that the governments appreciate themselves. So they have impact investors who are investing side by side with them. They get the vast majority of the assets returned, and they're able to use that money in line with their national priorities to really go after the projects that they've been wanting to do, but they haven't had the money to do. Yeah.
Thank you.
You're welcome.
I'm going to go from Catherine to Fiona, and Fiona Fintris, take it.
Thank you. So I'm going to really talk today about the role of civil litigation as part of the toolbox. So to start, my background, I am an out-and-out private practice lawyer. I started work in financial litigation, commercial litigation, predominantly in the English courts, but working around the world, either through English law and common law jurisdictions, also part of a multi-jurisdictional strategy. I'm not going to run away from the fact that I've been on both sides of the V. I've been claimant and defendant side. And what I'm going to try and do today is give you a balanced view on the pros and the cons, the opportunities and the risks of civil litigation, and also how it may fit together with other things as well, because I think these things can't be seen in boxes. They all work together. My pitch today really is, if the question is, how do we get our money back? The answer is sometimes, for the right case, in the right time, litigate like you're the corporate you're trying to get the money back from.
Exactly.
And what I'm going to try and do to get that answer is to start with some fundamentals in terms of what I'm talking about, civil litigation, the claims, the fora, the remedies, and then start bringing it to life through some opportunities, risks, and challenges. So to frame what I'm saying, civil remedies, what I mean by that is using commercial litigation to recoup damages and other amounts taken from claimants. This can actually be a huge range of different kinds of claims, very specific to different jurisdictions, so I'll keep it high level at this stage, and I'll obviously be a little bit English focused, but I think the points remain around the world. This can cover contractual claims. So I've entered into a contract that was a sham. How do I either undo that contract or get damages under the contract? Tortious claims, so where perhaps I want to go after a range of different parties that have been perhaps colluding with the contractual counterparties in some form of conspiracy, so I can broaden my range of claims by having perhaps one central and lawful means, but going after other parties who have been involved in it through an unlawful means conspiracy. Fraud claims, civil fraud, similar concepts. And also unjust enrichment and restitutionary claims, where perhaps my framing isn't what have I lost, but what have you gained? Similar sort of ideas, but perhaps put a slightly different way. I think one point that underscores all of that is that for all of these claims, I am talking about civil, not criminal, and therefore generally I have a lower burden of proof than a criminal standard. So I am pursuing a corporate in a civil court, and I have generally either a balance of reasonableness or balance of probabilities kind of approach. I'm not saying that makes it easy, but it does make it easier potentially than going after criminal remedies. In terms of where I do this, jurisdiction is obviously a very fact-specific question. It will depend a lot on the kinds of claim you're bringing, and there isn't always a single answer. To use Catherine's example of the telecoms contracts, you'll often find, as she alluded to, these contracts are written to English law and have either an English court clause in them or an arbitration clause in them, either because they're genuine contracts at the outset, and then to get investment in, they had to be written to a contract, to a jurisdiction of somewhere like the UK, or because arbitration's been chosen so that any dispute is fundamentally kept confidential. Sometimes they were outside of a clause saying where we have to bring this, and we have to do a much more wider analysis of where we can bring these claims in terms of jurisdiction. And it can often be there's more than one place to do this. So if I'm looking at a tortious claim where there's been a conspiracy, I might look at the place where the loss has been suffered, or the places where there have been actions where those losses have been caused. So that can really open up a huge range of different options in terms of where I can start litigating. Who's my defendant? Almost always, what I am doing, I would say it's against the corporates. I will leave the good work of going after the individuals to other people in this room. Mm-hmm. But really what I'm talking about is you've got a web that's happened here, and almost always in that web you will have a corporate or a corporate group who has benefited to an astronomically large amount of value. Mm. They may not be the direct fraudster, the direct party, but they are complicit throughout this. And I say, if you're a corporate, then you should be facing those civil remedies in the absolute normal way. And it really is looking at that corporate group, and that gives you defendants who are able to pay and have incentives not to be litigating these things through the courts for years. So they are very attractive defendants in terms of a long-term recovery of amounts back. And then my final sort of framing point is, who am I bringing the claim? it's the party usually that suffered the loss. I think the examples we're talking about here is almost always be the government. That can be a slightly complex question in terms of which exact body is the government. It's very important to get that right at the outset. But another layer on that is also it's perfectly possible to assign these claims to vehicles and be funky about how you structure these claims if there are some concerns around funding or about contagion. So you have to be very clear about the right person, but then you can be more flexible in terms of thinking about how you might apply that. I'm going to come on to some opportunities and risks, but just to pause for an example, and I apologize, I don't have slides, but I don't have a slide problem, so it's okay. One of the cases I can talk about, and there's lots I can't talk about, is I've acted for the last 4 or 5 years on English civil litigation in the context of the Mozambican tuna bond scandal. So I was working in the English courts on English litigation that ran alongside and after and before various different sets of proceedings in the US, in Mozambique, and in lots of different jurisdictions. I was acting in a pure commercial capacity, actually against the government. So there we go. Where the Mozambican government had gone to the English courts to seek declaratory relief to get out of very, very large state guarantees of multi-billion debts that it said it didn't owe, because these debts had been were shams, were tainted by bribery and corruption, and were not valid state debts. That can only be described as causing a pylon in terms of all the different claims that came in. This is all before the English courts, because all of the debt documents had been written to English law and the English courts, which was a necessary precursor to investors investing in this. My client settled, but other clients didn't, and that went to a 15-week trial at the end of last year, and we're waiting for judgments. I'm going to come back to that example because I think it's quite a nice example of different pros and cons in terms of how you use civil litigation to get what you want, perhaps not get what you want, and also thinking about how it works alongside other remedies. So that's my scene set. I'm now going to try and be very balanced in terms of the opportunities and the risks that I think civil litigation brings. Opportunity number 1, big damages. So the amounts I am talking about here, they aren't necessarily linked to an asset or to a particular pot. They are looking at damages generally. So I'm not particularly concerned here with tracing through what, that's the money, that's the pot that was taken. I'm looking at much more holistically in terms of what is the damage that has been suffered. And quite obviously, that opens you up to a potentially much larger number. Now, the exact mechanics of how any damages claim works will be a very specific question for lawyers to answer. But I think you can take this point that these sort of civil litigations can really give you some really big numbers. And importantly, as I've already made the reference, big numbers against defendants that can pay those big numbers. There is zero value to anyone in practice of having a really big number and a defendant that has no interest or cannot pay. And it's an absolute waste of everyone's time and money if that's the route taken. So I think one of the big opportunities of civil litigation is both the big number that's able to be claimed, but also the practical ability to get that big number of damages from a corporate party who is well able to meet that damages amount. And that's particularly the case where, as I said before, often we're talking here about a group of companies, perhaps more than one group. In mining or in telecoms, it's very often multiple actors. And so you perhaps don't have a single target, you may have multiple targets. So the points that I make about the recoverability of those amounts are sort of even more increased, where you perhaps have a number of different targets.
And just, we've been talking the last couple of days about advisors and advisor enablers. So yeah, unlawful means conspiracy, you can grab the enablers as well.
Exactly, and you often go through this quite strategic thought about who do I want as my defendants? Mm. That isn't a single factor discussion. I might have one defendant who is a brilliant defendant for the purpose of getting the money back because they have really deep pockets. I may have another defendant who perhaps doesn't have as deep pockets, but strategically they may open the doors in terms of leverage, documents, enabling. Mm-hmm. And so if you put them together as a package, you can really get quite a valuable sort of tool, I think, together in terms of recovery. So B might help A pay or whatever else, but
Exactly.
as you say, you can also add them together and get quite, a lot of comfort. Opportunity 2, which is related, which is this is multi-jurisdiction. So a lot of my experience is in England, but as I said earlier, a lot of that experience is working in England, but alongside other lawyers in other jurisdictions to put together a package of civil litigation. That can either involve one substantive litigation and then multiple enforcement strategies after the event, or running parallel proceedings. That comes with downside, it comes with cost, it comes with the need to manage different timings, standards, just different, I think, attention spans, and you don't want to spread yourself too thin. But you do also have an opportunity to use civil tools that may be better in one jurisdiction than another. So, for example, discovery and disclosure, a blessing and a curse, but it can be quite powerful. For example, in the US, very, very wide, long arm discovery powers, often in support of foreign proceedings. So you can mix and match sometimes some of your civil remedies, as long as you're doing it correctly, to be smart about how you are using different jurisdictions together. You aren't as bound sometimes as you may be in other regimes to be sort of in certain jurisdictions. Opportunity / risk, I accept this, so number 3, cost. So I'm not going to run away from the fact that civil litigation can be expensive. Catherine, you've thrown some numbers around which I agree with, and perhaps would sometimes think is at the lower end. It turns out.
We'll talk about it later.
I would reframe cost as value, which is certainly I'm not pitching here for every case is the right case for civil litigation. I think what I would say is, if there can be real value in spending money wisely on the right opportunity, with the right claim, with the right defendant in the right jurisdiction, where the potential recovery is so big that actually spending money to do it is a very clear cost-benefit analysis. On the other side, I will absolutely accept there are some cases where that doesn't weigh up, where you will spend more money than it's worth getting it. So I think the game in town here is to find the right opportunity to do this, rather than applying it across the board. But Catherine's already touched as well on some points that you can mitigate around that. You've got a very sophisticated and I think increasingly sophisticated market in terms of funding, insurance, risk awareness, where as long as you are aware of the different risks that you're facing in terms of costs, you can put products around you. So if you litigate somewhere like England, it is a loser pays jurisdiction. So if you lose, you pay up to around 75% of the other side's costs. Now, I would make 2 points on that. Firstly, that works both ways. So a defendant is also bearing that risk, and that shouldn't be understated. So you're bringing a good claim, the defendant knows it's going to have to pay not only the damages, but also your costs. That is a commercial driver to reach an actual outcome on this quicker than going all the way through to trial. And secondly, on your own side costs, there are ways to reduce that through insurance. So you can take that off the table if you're talking to a government or otherwise in terms of looking at that risk, insuring it, and dealing with it. So I think cost is a manageable concern, not something to be put off on the right case. Opportunity and risk, I accept number 4, and it's something, Dan, you talked on it earlier, which is, I'm going to call it kind of contagion risk, which is you pull at a thread and you never quite know what's always going to come out the other end. I think I absolutely accept your comment that civil litigation can open up risk of counterclaim. It can open up risk of other things coming out. None of us ever know what's always going to happen at the start of anything. I think we wish we said that we did, but we don't. Again, I think that just goes back to being informed about the risks you're opening up. So often civil litigation will have followed some other form of law enforcement, some other form of investigation. So that by the time you're thinking about civil litigation, you've probably gone through quite a lot of work to really understand your universe of risk. So again, I think it's just something you need to be informed about and shouldn't deter good claims being brought through good civil litigation. On the other side of a risk contagion point, the corporates that are involved in some of these large fraudulent schemes are not doing it in a single jurisdiction. They haven't just got lucky. They haven't just fallen into a situation. They are working across the globe, particularly in certain sectors. So that risk, contagion, I guess publicity as well point, does also work on the other side of the V for the defendants. And certainly in sort of crafting a litigation strategy, which involves you also crafting a settlement strategy, understanding how the defendant is seeing this, how the defendant's stakeholders are seeing this, particularly if a defendant is listed and has stakeholder pressure, has to announce, has to reserve for claims, has to make disclosures to the market. The contagion publicity side of things, if managed correctly, can actually be a huge weapon rather than a risk. So again, I think it's one of those things that being aware of it from the start and owning it is a positive in the right case. Fifth, and actually this is really important, I don't know why I put it fifth, but it's a big one, which is disclosure and documents. I'm going to slightly pitch against myself, but the ability to get disclosure is a wonderful thing sometimes, but it also puts a burden on anybody bringing litigation. So in the UK, in the US, in common law jurisdictions, there's generally a rule in civil litigation that if you're going to litigate, you have to give over documents that relate to your case and often that are also adverse to your case. So you sort of open up your wardrobe and say, here it all is, and the court should decide on the basis of that. That can be a hugely powerful tool for information gathering in terms of supporting your case, in terms of making the defendant go through its emails, its WhatsApps, its advisors' WhatsApps, all that stuff to get information out. It does also require generally the claimant to do the same thing. Without any judgment or criticism, one of my experiences in the Mozambican litigation in England was that was a difficulty for a government to engage with. No lack of willingness, I think, from most parties, but I think a lack of preparation at the start of a proceedings, understanding that coming down the road 2-3 years after litigation started would be an obligation on the government of Mozambique to effectively disclose a huge amount of its documents, was perhaps something that was not thought through at the start. And with political change, with time, with resource difficulties, these things can be quite problematic. So it's an observation that if I've managed to convince you that civil litigation is the right tool and for the right case with the right legal team giving you value, not cost, then I think it's really important that it's done in a practical way where parties are going in with their eyes wide open and as much work is done at the beginning to prep these things right so that you don't get halfway through and realise that you sort of aren't able to meet your own obligations and therefore sort of, shoot yourself in the foot.
I have a follow-up question. For everyone here, could you explain what constitutes damages? What are the types of damages that you would be looking at when you're speaking to the government of Mozambique to say, these are what we identified as the damages that we think you could pursue civilly?
So I could do about 3 hours on this, but let me do 2 minutes.
Yes, you have 2 minutes.
So starting point generally is if the corrupt means had not happened, what position would I have been? That can vary. So if I've entered into a contract because of misrepresentations, because of bribery, then what have my losses been caused because of that? That can then open up a huge amount. You often have your direct losses, which is what have you directly suffered because of this. So if you would have entered into a similar contract with a bona fide counterparty, what's your counterfactual? What would have happened in that scenario? That's sort of my box one in terms of main. But then you can start going into a world of consequential losses. So if A happened, then B happened, then C happened. So to use Mozambique as an example, and I said I was on the other side of this, but they were claiming losses in respect of the debt arrangement, but then consequential macroeconomic losses in terms of we had to restructure this debt. That came with it these huge amounts of other losses that went alongside restructuring a debt, massive knock-on implications with IMF funding, with a huge amount of internal funding, and they claim those. Now, I haven't got a judgment yet, but I think my point is that you may have sort of a direct set of losses which directly stem from the transaction, from the fraud, but that can also then broaden out quite a lot in terms of much more indirect losses and can get to be some quite significant numbers.
It's very interesting. I'm going to hand the mic off now to Jamie Smith from SIDA.
Thanks, Deb. Yes, I work for the Swedish International Development Corporation Agency, SIDA, in the Global Policy Support Team working with anti-corruption issues. We're responsible for allocating just under half of Swedish Development Corporation assistance, so about 2 billion euros across around 2,000 regional, global, and bilateral programs every year. So why am I sitting here? Why is this conversation interesting to us? Well, one of the best things about attending a conference like this is that you hear about so many good things happening around the world and so many things you would like to support as a donor. But one of the worst things is, of course, that's impossible, and the aid world is under a lot of strain at the moment. In Sweden, we've just left the 1% of our GDP target to go to development cooperation. Similar things are happening in UK, Finland, France, and then of course we have a lot of funds correctly diverted to Ukraine right now. And then this trend in aid is of course leading to more questions about how do we achieve the SDGs, so the funding gap to the SDGs. And in most development agencies now, we're talking about financing for development all the time. And that's really about looking beyond our official development assistance and looking at ways we can support governments to raise domestic resources and other sources of finance for their investments. So this kind of asset recovery question has, if you like, two aspects of interest to donors. The first one is it can potentially be a source of funding for the things we care about, schools, hospitals, roads, etc. But of course, it could be even more meaningful if the numbers go from the tens of millions to the hundreds of millions. So as Fiona mentioned, the damages side. That's one bit. But the second and much more important one is actually this is the deterrent effect. This is the potential of the deterrent effect when you have these kind of sizes of claims potentially that could be explored, because this type of activity is what robs countries of the domestic resources for schools, hospitals, and roads. So it's that two sides, the financing part, the asset recovery bit, but more importantly, the deterrent effect. And this is a bit like the things that we've been talking about, civil litigation, is a bit like turning the enablers against themselves to try and achieve deterrent effects. So what do we SIDA do in this area at the moment of broadly illicit financial flows? So we have the 2015 Mbeki report had this nice slogan, stop it, track it, and get it. Our work has been more on the stop it and track it side so far, and particularly focused on supporting civil society and investigative journalists to work and lift those issues. On illicit financial flows, we've supported TI globally and nationally over many, many years on their illicit financial flow work. We have a regional Africa program on domestic resource mobilization, which supports regional African organizations like the Tax Justice Network Africa and AfroDad and TI Kenya to drive the IFF agenda. And we've got lots of support to investigative journalists to uncover illicit funds and reporting illicit funds. And we've also been very active on the tax side. So we've supported the OECD Tax and Development Program that has a lot of work on automatic exchange of tax information and BEPS. But what we haven't done so much work on is this get it part of the equation. And that's why we're kind of curious to follow these discussions about civil procedures because of the potential impact as a deterrent and as a financing flow. So why is this work interesting? So three main reasons why this kind of discussion is interesting for us. The first one is a kind of pragmatic one. It's the reduced aid budgets and that we've been targeted specifically by our government to look at ways of collaborating with the private sector to find new resources. And that's not just in the traditional areas of private sector development or infrastructure. That's across all of our areas, democracy, journalism, etc. We are curious also to know whether there are some viable models here that can be developed to give countries that lost out to in big ways to find out if there is a model here to be found, the types of ones that Catherine and Fiona have described, whether there is a model that can be used at a scale that we haven't seen before. And finally, we think that potentially some of these cases, if they work, could have a even bigger effect on the balance of incentives. So the cost-benefit analysis of getting involved in something as a corporate or as a enabler, as a law firm or accountant, could be shifted if you see some of these successful civil cases. But that said, there's a number of considerations to give a balanced view like Fiona. Many different considerations, and I'm interested in having the debate with all of you about these questions. But the first question is sort of how do you ensure as much transparency as possible without jeopardizing the cases themselves? And linked to that is the role of civil society and all this. Dan, you mentioned the importance of involving civil society, and that's critical in all this. And while we've, in our discussions with the team here, have put them together with our civil society partners to see, is there something that can be done here? The second question is, what happens if a government changes or goes in a negative direction for democracy? What's the playbook then? What do you do? And then the final question is the one that Dan mentioned as well. How do you make a kind of really solid and well-developed plan for the repatriation of assets if they are won in a claim? And that should be building on the good practices that have been developed over the last 10 years on asset recovery. So in summary, we as a donor are interested to follow this work, see how some of these models could be developed, can they be part of the toolbox, and to see how some of the risks that we mentioned can also be managed. Thank you.
Thank you, Jane. We're going to open to discussion and questions. Let's see, do we have a mic? We're going to take, we'll start with 3 questions. Yours?
Hello, thank you, Daniel, for this very insightful observation of the legal framework and at least in theory and definitions about the confiscation. And my name is Mihail Boyagiev. I work for Basel Institute on Governance. We work in Bulgaria, which is part of the European Union. So I would like to bring a little bit your perspective here, because just recently you adopted a new directives on asset recovery and confiscation, and then there is a pending a new EU directive on combating of corruption, where all these issues have their reflections. And my question is more of a comment maybe from all of you, is traceability to a crime, because when you're discussing a corruption, it's a crime. I understand all these civil remedies, etc. But what we're doing when there is no capable law enforcement or oppressed law enforcement by local oligarchs to conduct an investigation or even to detect certain crimes. And this is an issue we're struggling in Bulgaria as well. So I think this you find somehow remedies of when you don't have very active law enforcement institution on the local level to detect the crimes. And secondly, I'd like to stress on the fact that one of the issues is also it reflects the situation in the European Union is the criminal liability or liability of corporations, which is something which is also a pending issue, and maybe this is not an issue for the Commonwealth or the English-based system, while in the continental European Union, this is an issue of the criminal liability of the corporations. Thank you very much.
Okay, well, second question, and then we'll take yours after. You'll be 3. This gentleman, front row. Yeah.
Thank you. My name is Olugbemi Jaibo from Nigeria. I have a couple of questions. The first, with respect to civil forfeiture in the US, where the assets are economic assets. For example, an ongoing hotel, and as a final order of forfeiture, how does the government do that? Do they continue the management of the economic assets? Or there's just a sale at whatever price and a repartition of the monies? My other questions will go to SIDA and to the lawyer from the UK. And within the context of enablers, so much money was recovered from Abacha all over the world. But for the most part, the government of Abacha was under international sanctions. So how did all this money find lodgment in the West? And in recovering those monies, how many enablers were prosecuted? How many banks were sanctioned? And how did those monies get there? Because if that part of the narrative is not made known, then there's a problem. So that's one of my concerns. And then the other thing is with the British administrative system. About a year or two ago, we had the P&ID case against Nigeria, in which the company did absolutely nothing, but got millions, tens of millions of pounds in awards from the British commercial arbitral system. So, and we begin to wonder, even with the way in which you get so scared of being sued in the British system, is the British judicial system not becoming an enabler of corruption? And then now my question to SIDA will be, when we talk of ODA, that makes the governments more like beggars. When we talk of IFF, we become demanders. And it seems there's a difficulty in making that power shift to make governments demanders, and rather than keeping them beggars on ODA. ODA is less than 1/10 of IFF. So we don't need monies from ODA for SDGs if there can be a stoppage of IFFs. Just want your comments on that.
Okay, we're going to take the question over here.
Hi, is that on? Hello. Yeah, my name's James Bolton-Jones. I work at a UK-based NGO called Spotlight on Corruption, where we follow a lot of the cases that have been mentioned, including the Tuna Bonds case and the P&ID case. My question was around settlement. So in particular, in the Mozambique Tuna Bonds case, the settlement meant that although Mozambique did avoid the risks of going into the full civil trial, there was a real lack of transparency, and the Mozambican people were still in the dark about kind of exactly what went on and how all this happened. So I'd be interested to hear panelists' comments on the risks that these kinds of settlements have and on sort of impacting on the transparency of these kinds of cases. Thanks.
Okay, Dan, do you want to start with the first question from our Bulgaria?
Sure. Thanks everyone for the interesting questions. I think sort of one of the challenges in the international framework is we, of course, have different laws in different jurisdictions, and that means they don't always translate well from place to place. And so I think some of the developments that we're seeing in the EU and over the past several years, like the mutual recognition of confiscation judgments within the EU, I think is not only an important tool for European jurisdictions, but it's also a good learning opportunity for the rest of us. How are we going to make a better effort at simplifying our procedures to be able to enforce each other's judgments? And I think with the new EU mandates for non-conviction-based confiscation, hopefully that will make some of the differences between systems sort of diminish, and that we'll have more opportunities for that. And so I follow with some interest the developments in the EU a little bit on that. I think the other question of how is it that how do you deal with a situation where law enforcement doesn't have the capacity, the resources, the experience to take on some of the large corrupt officials or enablers around corruption? It's a perennial problem that we have, and it's going to be a case-specific challenge. Sometimes I think where you can partner up with a foreign law enforcement, that's going to be the best way, because there's going to be part of the crime in other jurisdictions, and that brings more resources in. It helps the investigators in the countries affected not only learn from their experience with their partners, but also it brings new tools, because the laws in each of the different countries are going to be weak in some places or strong in other places. And so if together, in a not necessarily a joint investigation, but parallel investigations perhaps, that can solve some of the challenges. But it's not there's no one size fits all for that.
Yeah.
Go
If I can hop in on that as well, having worked in some of the jurisdictions that you're discussing, one of the issues that we often saw is that the local investigators, not only were they under-resourced, but sometimes they got threatened as well. And even in some jurisdictions where you would be surprised, where people get threatened, they do. So it's one of the reasons why, from our perspective, we think the type of enforcement where you're looking at these sorts of fraud claims, where essentially you're using large firms in the UK, in the US, depersonalizes some of this work, and it also protects some of the whistleblowers as well. So we've had cases informally passed to us by law enforcement in some of these jurisdictions saying, this is too hot for us, maybe it's something you can do.
And I'm going to chime in on that too, because after being an FBI agent for 20 years and investigating these crimes, and I was the case agent on Abacha, so what you find is that evidence exists in many jurisdictions, because Dan and I had cases where the law enforcement was not independent. But what you find is that the money went to the UK, that the money went to Australia, the money went elsewhere. And I remind people all the time, in a money transaction, the money moves through multiple jurisdictions. So for one transaction, evidence can exist in 4 places, right? In 2 correspondent bank accounts. It can exist in the country of origin. I have had cases where the corrupt regime owned the bank, so I couldn't rely on the bank records that I received. But if there was a transaction and then I don't see that same transaction in the in the movement, then I can disregard that and say, this is not good evidence, but I have evidence elsewhere. And so you would be surprised. For the last 8 years, I investigated as non-law enforcement after I retired from the FBI, and you would be surprised what you can find open source and what is publicly available. And people ask me all the time, like, what do you miss from being an FBI agent? I'm like, subpoena authority. I like bank records, right? But if you have a corrupt leader and he's been in office for 20 years and you know what he was like when he came into office, you can say, look, his salary was the equivalent of, $20,000 a year, and yet he's amassed a $100 million fortune. So there's lack of evidence. There's evidence to support that this is not legitimate income. And don't forget, in civil cases, it is a preponderance of evidence. It is, more likely than not. And so it's very obvious sometimes to a jury that, look, his salary was $20,000 a year. And first thing I would do is the net equity. Like, this is what he makes, this is what he spends. Like, he shouldn't, there's no legitimate way he recovered earned $100 million. So there's a lot of investigation that can be done outside or working around a foreign law enforcement that is less than cooperative. We're going to move to your question about like hotels and seizing corporations. Dan, you want to start with this one, and then anyone else who would like to chime in?
Yeah, certainly. There are all sorts of types of assets that are costly to maintain, and if we do restrain property, we do have to maintain it, both for ourselves if we are successful in confiscating it, but also if we lose, so that we are not, putting the person at a disadvantage from having a wasted asset. When it comes to things like hotels, ongoing businesses, animals, things that eat, we have to do our due diligence ahead of time before we take any action where we actually become responsible for the maintenance. And so we would do what our colleagues in the U.S. Marshal Service would call pre-seizure planning, and try and figure out, do we really need to restrain it? Do we really need to seize it, or can we just prevent people from selling it in a way? And so that is like a real concern. And unwinding things when we do confiscate assets can be complicated. Selling high-value hotels or projects. So we've had that come up in the 1MDB case. There were several hotels that were owned in that case, and they're costly and complicated to unwind. I would also say that in the Abacha case, you mentioned the enablers and people involved, and what were some of the sanctions against some of the financial institutions or people who facilitated the conduct. I mean, we're talking about conduct from 1995, 1998. And so I think we're in a different environment now, where I think there are more tools and there's more enforcement actions that are brought against people and institutions that are involved in criminal conduct. So, for example, in that era, I think some of the money laundering theories and the laws were not as strong, and some of the regulations were not as strong. And so the compliance tools, whether it was regulatory or law enforcement, didn't give countries as much reach to go after those enablers. Whereas in the 1MDB case that I mentioned, we not only went after the people involved in the underlying sort of embezzlement and investment fraud scheme, but when our investigation became broader, because we got into it a little while later, we brought in some of our colleagues, for example, from our Foreign Corrupt Practices Act side of the game, and they were able to bring charges against Goldman Sachs and one of its subsidiaries for their involvement in facilitating loans to Malaysia that were corrupt loans. And so I think there's more enforcement now, and there are more tools. And so I'm hopeful. I'm sure that we're not going to get all criminal conduct. There's just no way. But I think that it's a different environment now, and hopefully there will be more accountability now.
And I think also a part of that comes down to, again, manpower, time, the number of cases investigators have. So at some point, it's not diminishing returns, but you can only go after, I mean, these cases as it is take, anywhere from several years to a decade or more. And at some point, you're just like, well, what was our mission? Our mission was trying to recover looted assets. Right. Who would like to address?
Could I quickly just
yes.
very quickly respond to the ODA question? Just to say, totally agree with you. The ODA picture should be, and it is, a small part of the bigger IFF question. And then the question for us working with official development assistance is, what can we do that is catalytic and has a multiplier effect on those other financing flows, particularly domestic resource mobilization, of course. So, but totally agree with the point.
Who would like to address James's question?
Shall I do that? I think I know. And it probably comes back also to a transparency point and the sort of English legal system, which I think covers both those points. So I'll make a couple of observations. I think some of the issues with P&ID were arbitration, not the English courts. And the English courts actually have a principle of open justice, which goes to the point. And I would hope certainly for the English courts, and you see this around the world, that there is a genuine, as far as can possibly go without undermining the case, there is a willingness to allow the world at large to understand what's happened in civil litigation. And certainly the English courts did give journalists access to files in the Mozambican case, which you're talking about. Now, that has to, I think, have some end point in civil litigation. The point of civil litigation is not necessarily to deliver transparency. That's why it's part of a toolbox. Fundamentally, what you're trying to do in civil litigation is get the money. And if that means get the money through a settlement, that might be the right answer. And if that has consequences, that means that the world at large doesn't know what happened, then that has to be weighed up against the benefit of getting the money. Taking that back right to the start, that I think what that means is you need to have the conversation at the beginning of the litigation, get civil society in the concept of litigation, so they are satisfied this is the right process from the outset. And there are other ways to get those transparencies through local investigations, things like that. I don't think there can be any one-size-fits-all outcome on this. And I think everything we're talking about has its pros and its cons. And I think what we're trying to put together is the best jigsaw on this. But yeah, I think overall, I think the English court's still very transparent. Arbitration, I can have an offline discussion with you about. And yeah, hopefully there's a sufficient view of that across the world.
And for our perspective at Restitution, one of the things that we do is we work with civil society to develop claims. So what we find is often civil society is the first to know, has the most in-depth information and knowledge. And we actually get most of our tips from civil society. And civil society then works with us to, in a sense, develop the claim, but also develop what will happen once that money is returned. So it becomes very holistic with civil society. We're probably one of the few impact litigation funders where most of our tips come from bishops. We get calls from religious people all the time. So 2 of our largest cases came from 2 archbishops in different countries. So at that sort of working holistically with civil society, we also find that that's useful. And a lot of people do talk about this, particularly in the anti-corruption space, that civil society is really on the front line on this. So what we can do is provide a different pathway for that information. So civil society then can potentially become expert witnesses. That expert witness then goes into the court proceedings where civil society is then able to say, okay, this is the money that should be returned. So it's another pathway for the information, and it also provides protection because you have lawyers, investigators, everything, all over everything. So it becomes harder for particular bad actors, and we know they do, to target civil society, either legally or illegally as well.
Yeah, and I will say from an investigator standpoint, law enforcement is much more open today than they were more than a decade ago of talking to civil society and investigative journalism. When I was with the FBI, we did not talk to journalists at all. Under Louis Freeh, no comment was a comment. And so the role that civil society is playing now in transparency is vital to almost every international corruption investigation, wrongdoing by corporate actors.
Yeah, and data collection, right? So a lot of the analysis we do is the quantum.
Exposure, data collection, all of the leaked, different types of leaks, Pandora Papers, Panama Papers, the list goes on.
Can I just come in quickly on the transparency issue? Because I think our experience as a sort of sometime dabbler in the UK courts, because some of our proceedings bump up against it, it seems to me that the UK courts are less transparent than in the US. In the US, the default position is that if it's filed in court, it's on the public record. You have to have a good reason for it to be protected and put under seal. And you have to justify that to the court, and the court doesn't always grant it. And so I think in sort of taking a step back, and why are we doing asset recovery? I think there are a couple of different reasons for asset recovery. And at least when it comes to the confiscation proceedings, I think there's we're trying to fight impunity, and so it's showing that people can't maintain the assets that they got through illegal means, and sometimes putting the information out there as to how they got that is just as important as the amount of money that's recovered. Certainly, where we can remediate some of the harm, that's an important objective. But I think at least when it comes to tracing the proceeds that someone earned, like a public official earned from their corruption, earned in a bad way, I think it's hard for us to conceive that we're actually going to collect all of the assets that they got. But in our Abacha litigation, there were some actions in the UK court that were hidden. There was a secret deal at one point where there was sort of civil litigation in the UK where the government of Nigeria and one of the claimants in our case tried to release assets from a freeze that the UK authorities had imposed at our request through an agreement that nobody was aware of, at least the other parties to the litigation in the U.S. And that was concealed and would have remained concealed in the UK proceedings, but it was not when we got a hold of the documents and were able to file them in the U.S. courts. So I think there are some differences, and there are some challenges with transparency.
That's why we use strategic communications in litigation is very important. So it's outside of the court system, but for a lot of us, strategic comms and getting that information out in the market is something that experts do, and we use them. Everybody does.
Yeah. So we have taken up 90 minutes of your morning, and I want to thank everybody for being here. I want to thank my wonderful panelists for being here as well, and thank you very much.